The Commerce Clause. Common interpretation by Randy E. Burnett and Andrew Koppelman. In the 13 years between the Declaration of Independence in 1776 and the adoption of the Constitution in 1789, the United States was governed primarily by 13 separate entities. Although the form of each government differed, most tended to elevate the legislature above the executive and the judiciary and made the legislature as responsive to mediatorial settlements as possible. State legislatures began enacting laws to relieve debtors who were numerous for their debts, which undermined the rights of creditors who were few, and the credit market. States also erected an assortment of trade barriers to protect their own businesses from competing firms in neighboring states. And because state legislature controlled their own commerce, the federal Congress was unable to enter into credible trade agreements with the foreign powers to open markets for American goods, in part by threatening to restrict foreign access to the American market. The result of all this was a nationwide economic downturn that, rightly or not, was blamed on ruinous policies enacted by democratically elected legislatures. In 1787, political dissatisfaction with the economic situation led to a convention convened in Philadelphia to remedy its state affairs. The new constitution it proposed addressed debtor relief laws with the Contracts Clause of Article 1, Section 10, which bars states from impairing the obligation of contracts. To address the problems of interstate trade barriers and the ability to enter into trade agreements, it includes the Commerce Clause, which grants Congress the power to regulate commerce with foreign nations and among the several states and with the Indian tribes. Moving the power to regulate interstate commerce to Congress would enable the creation of a free trade zone among the several states. Removing the power to regulate international trade from the states would enable the president to negotiate and the Congress to approve treaties to open foreign markets to American-made goods. The international commerce power also gave Congress the power to abolish the slave trade with other nations, which it did effective on January the 1st, 1808, the earliest date allowed by the Constitution. But in the words of Chief Justice John Marshall, the enumeration of 3 distinct commerce powers in the Commerce Clause presuppose something not enumerated, as that something, if we regard the language, all the subjects of the sentence must be the exclusively internal commerce of a state. Gibbons versus Ogden, 1824. So, for example, even when combined with the necessary and the proper clause giving Congress power to make all laws which shall be necessary and proper for carrying into execution its enumerated powers, the Commerce Clause did not give Congress power to touch slavery that was allowed by state governments within their borders. The text of the Commerce Clause raises the list of 3 questions of interpretation. What is the meaning of commerce? What is the meaning of among the several states? And what is the meaning of to regulate? Some have claimed that each of these terms of the commerce power had, at the time of the founding, an expansive meaning in common discourse, while others claim the meaning was more limited. Bullet point 1. Commerce might be limited to the trade, exchange, or transportation of people and things, which would exclude, for example, agriculture, manufacturing, and other methods for production, or it might expansively be interpreted to refer to any gainful activity or even to all social interaction. Bullet point 2. The wrangling might be limited to make it wrangler, which would subject a particular type of commerce to a rule and would exclude, for example, any prohibition on trade as end in itself. Or it might expansively be interpreted to mean to government, which would include prohibitions as well as pure regulations. Bullet point 3. Among the several states might be limited to commerce that takes place between the states or between people's different states, as opposed to commerce that occurs between persons of the same state, or it might expansively be interpreted to refer to commerce among the people of the several states, whether such commerce occurs between people in the same state or in different states. In addition to other pervasive evidence of the public meaning of these terms, the slavery issue helps clarify the original public meaning of these terms. At the time of their enactment, commerce meant the activity of selling, trading, exchanging, and transporting goods to people, as distinct from producing the things being moved. To wrangle it meant to make regular, but at least with respect to the international trade, it also included the power to ban the trade in some items, as Congress banned the slave trade among the several states meant between one state and others, not within a state, where slavery exists as economic activity. From the founding until today, the meaning of commerce has not been much changed. Perhaps its only expansion by the Supreme Court came in 1944, when the court held that commerce included a business such as insurance, which for 100 years had been held to be solely a subject of internal state regulation. United States versus Southeastern Underwriters, 1944. Instead, the modern growth of Congress' regulatory powers has been allowed by the courts adopting an expansive reading of the necessary and proper clause to give Congress power over a broad range of interstate economic activities with a substantial effect on interstate commerce, when such regulation is essential to the regulation of interstate commerce, narrowly defined. As the New Deal Court said in United States versus Darby, 1941, the power of Congress over interstate commerce is not confined to the regulation of commerce among the states. The court explained that while manufacture is not of itself interstate commerce, the shipment of manufactured goods interstate is such commerce, and the prohibition of such shipment by Congress is indubitably a regulation of commerce. The power also extends to those activities interstate which so affect interstate commerce, or they exercise the power of Congress over it as to make regulation of them appropriate means to the attainment of a legitimate end. They exercise the granted power of Congress to regulate interstate commerce. As authority for this principle, the court relied on the necessary and the proper clause case for McCulloch versus Maryland, 1819. But in McCulloch, Chief Justice Marshall insisted that should Congress, under the pretext of executing its powers, pass laws for the accomplishment of objects not entrusted to the government, it would become the painful duty of the tribunal to see that such act was not the law of the land. In Darby, however, Justice Stone wrote, whatever the embodied purpose, regulations, commerce, which do not infringe some constitutional prohibition, are within the plenary power conferred on Congress by the Commerce Clause. In this way, Stone rolled out Marshall's inquiry into whether Congress was relying on the Commerce Clause power as a pretext for passing laws that aimed to accomplish goals beyond the powers of the federal government. Thus, the court expanded Congress' power over interstate commerce in a way that gave it a power over the national economy. In the 1990s, the Rehnquist Court treated this New Deal cases as a high watermark of congressional power. In the cases U.S. versus Lopez, 1995, and U.S. versus Morrison, 2000, the court confined this regulatory authority to interstate economic activity. In addition, in a concurring opinion in Gonzalez versus Riach, 2005, Justice Scalia maintained that under Lopez, Congress may regulate even non-economic local activity if that regulation is a necessary part of a more general regulation of interstate commerce. Most recently, in the healthcare case of NFIB versus Sebelius in 2012, a majority of the justices found that a mandate to compel a person to engage in economic activity of buying health insurance was beyond the powers of Congress under both the commerce and necessary and proper clauses. The individual mandate cannot be upheld as exercise of Congress power under the Commerce Clause. Chief Justice Roberts wrote, that clause authorized Congress to regulate interstate commerce, not all the individuals to engage in it. Moreover, even if the individual mandate is necessary to the acts of insurance reforms, such expansion of federal power is not the proper means for making those reforms effective. Instead, Chief Justice Roberts provided a fifth vote to uphold the Affordable Care Act by adopting a saving construction that the penalty enforcing the insurance requirement was non-coercive enough to be considered a tax rather than a Commerce Clause regulation. The dispute over the meaning of commerce turns in large part on the purposes one attributes to the clause and to the Constitution as a whole, and what one thinks is the relevance of such purposes to the meaning of the text. And in Philadelphia in 1787, the convention resolved that the Congress could legislate in all cases to which the states are separately incompetent, or in which the harmony of the United States may be interrupted by the exercise of individual legislation. Two records of Federal Convention 22, Maxis of Farland, and 1991. See also one record of Federal Convention 21, Resolution 6 of the Virginia Plan. This was then translated by the Committee for Detail into the present enumeration of powers in Article 1, Section 8, which was accepted as functional equivalent by the Convention without much discussion. Proponents of expansive reading claim that the power to regulate commerce should extend to any problems the states cannot separately solve. Those who support a narrow reading observe that the Constitution aims to constrain as well as to empower Congress, and the broadest reading of the commerce power extends well beyond anything the framers imagined. And dissenters in the healthcare case observed, Article 1 contains no whatever it takes to solve a national problem power for the reading. Okay, the next section is the matter debates. The first part will be why Congress and the courts should obey the original meaning of the Commerce Clause by Randy E. Burnett. As Professor Koppelman and my jointly authored essay shows, abundant evidence, including what we know about the slavery and the time of the founding, tells us that the original meaning of the Commerce Clause gave Congress the power to make regular and even to prohibit the trade, transportation, or movement of persons, goods, from one state to a foreign nation, to another state, or to an Indian tribe. It did not originally include the power to regulate the economic activities such like manufacturing or agriculture that produce the goods to be traded or transported. We should follow the original meaning of this provision. For the same reason, we limited California to the same number of senators as Delaware, notwithstanding the vast disparity between their populations, or limit the present to a person who is at least 35 years old, so some who are younger than 35 might make excellent presidents. A written constitution is the law that governs those who govern us, and those who govern us, whether the Congress, the President, and all the courts, can no more properly change the law that governs them without going through the amendment process, Article 5, than can the people can change the speed limits imposed on them without going through the legislative process. Moreover, under Article 6, the senators, the representatives, and the number of the several state legislatures, the law, executive, and judicial officers, both the United States and of the several states, shall be bound by oath or affirmation to support this Constitution, referring to the written Constitution. But such an oath would be meaningless if it was merely promised to obey whatever meaning a government official later wants the Constitution to mean. That would be like taking an oath to this Constitution while crossing one's fingers behind one's back. I agree with Professor Koppelman that the founders attempted to distinguish the problems that were best handled at the national level from those best handled by the states, but they did so by drafting a specific list of such powers, rather than leave it to the national authority to decide the scope of its own power. Where later developments justify ending to these national powers, such expansion is probably handled by the Article 5 constitutional amendment, and the Constitution was once meant to give Congress the power to prohibit the interstate economic activity of producing and selling alcohol. See the 18th Amendment. Enforcing the original meaning of the Commerce Clause does not mean that other economic activities are free from any government regulation. It merely means that the power to regulate all interstate economic activity reside with each of the 50 states, where national uniformity and coordination between states are desirable. Those goals can be achieved by the Interstate Compact Clause of Article 1, Section 8, by which states may enter into agreements or compacts with another state or states, provided they have the consent of Congress. Many such compact exists. I identify some of the key advantages of decentralizing most lawmaking at the state level in my statement on federalism. Here is a summary of my analysis there. Bullet point: federalism makes regulatory diversity possible. Given widespread disagreement about both economic and social policies, lodging this regulatory power in the states enables a diversity of approaches to develop. When it comes to economic regulation, so long as they remain within the proper scope of their power to protect the rights, health, and safety of the public, 50 states can experiment with different regimes of legal regulation, so the result can be witnessed and judged rather than endlessly speculated about. States will be somewhat inhibited in imposing restrictions on business by the threat of regulatory competition. Other states will be induced to offer more receptive business climates to entice businesses to relocate. Businesses small and large can decide to relocate if they deem a particular scheme of regulation to be too onerous. Bullet point: food voting empowers the sovereign individual citizen. When it comes to liberty, the competition provided by federalism empowers the sovereign individual. Each person can individually control the state in which they live by selecting from among 50 choices, not just two, and they can witness economic